Well, this goes back to the old adage that a successful negotiation involves convincing the person on the other side of the table that it's in that person's best interest to do what you're proposing. Appeals to compassion or mercy generally aren't going to get you very far in the financial world. So what are you doing in a Chapter 11? Well, you're reorganizing your finances, coming up with a plan of reorganization that will make the paying of these various obligations that you have, whether it's a you as in an individual debtor or a you as in a business, make those debts manageable so you can stretch the paying off of them over time, perhaps with some reduction in the sizes of the debts. So the first thing to find out is what's important to that particular creditor. If they take the position, I got to be paid in full, well, that's the kind of thing that unless it's a secured debt or what's referred to as a priority unsecured debt, is generally not going to happen in a successful Chapter 11. So that means that if the creditor is being adamant on that, we have to appeal to that creditor's self-interest in a little different way. In a Chapter 11, one of the requirements of a Chapter 11 plan is it satisfy what we refer to as the Chapter 7 liquidation requirement. So what does that mean? Well, Chapter 7, of course, is a very different concept from Chapter 11. In Chapter 7, if the debtor is an individual, the debtor, prior to filing, will have assets, will have debts. When the debtor files the petition, the act of filing the petition creates a bankruptcy estate. What goes into the estate is anything the debtor owns or has an interest in on that day. Now, if it's an individual debtor, the law does provide the individual debtor the opportunity to take stuff out of the estate, and we do that using exemptions. And in California, this isn't the same coast to coast, but in California, we have two state exemption tables that we use, and we really don't use the federal table. One table is for homeowners with equity, the other's for everybody else. So anything we can take out of the estate belongs to the debtor. Anything we can't, in a Chapter 7 bankruptcy, belongs to the Chapter 7 trustee appointed to the case to take and sell and have money to distribute to the creditors. If we're talking about a non-individual debtor, a business, there is no concept of exemption. Instead, everything goes into that bankruptcy estate, and in a Chapter 7, all of that stuff is liquidated to have money to pay creditors. So what we take out of that is, in a Chapter 7, it's possible for creditors to get paid. They might not get paid 100%, but they will get paid. In a Chapter 11, as I said a little bit ago, we are propounding a plan to repay the creditors something. The bare minimum that those creditors have to get over the life of the plan is what they would have gotten if you'd done a Chapter 7. So we understand how that's going to happen in a Chapter 7. The Chapter 7 trustee will liquidate assets and pay creditors. So we can come up with a dollar amount. Now, generally, we're going to subtract from that the amount the Chapter 7 trustee would get in trustee fees and also the cost of liquidating the assets. So we have a sum certain to work with. If we have an obstreperous creditor who simply will not go along with what we're propounding, well, then we can appeal to that creditor's self-interest. And that self-interest is found in the Chapter 7 liquidation requirement. This is how much you'd get if we did a Chapter 7. We'll give you a little bit of a premium. So just to choose some numbers at random, let's say you owe creditor ABC $100,000. And in a Chapter 7, creditor ABC would get, let's say, $15,000. Well, you might say, that's what you get in a Chapter 7. We are prepared to give you $25,000 spread out over the life of the plan. So what would you prefer? that we get stuck in Chapter 7. You have to wait for the Chapter 7 trustee to sell the assets, go through the whole mechanical process of that, and all you're going to get is $15,000. We'll give you $25,000 spread out over some time. And that can frequently encourage a creditor, convince a creditor who is having a tough time accepting the proposed plan to go along with it. Now, sometimes we can approach creditors even before we file the petition and see what it is that they want. And if we can craft a plan that satisfies that, then we have what's sometimes referred to as pre-packaged. That is, we've got everything lined up, so when we file that Chapter 11, it's a very streamlined process. The creditors vote in favor of confirmation. The judge confirms the plan, and off we sail into the sunset, making the payments to the creditors. But frequently, the people that come to me wanting to do a Chapter 11 don't have the luxury of a lot of pre-petition time to do that sort of negotiation. So that means once we're in the Chapter 11, we like to toss out feelers. Now, there are some limitations on what we're allowed to do. The Bankruptcy Code does prohibit a debtor from doing what can be thought of as lobbying a creditor to vote in favor of a particular plan. Doesn't mean we can't negotiate to see what's at stake in that creditor's mind. But if we've got a plan that has not yet been presented to the court, and maybe if it's not a subchapter 5, a disclosure statement, we say, here's the plan, we'd like you to vote on it. Can't be done. We have to wait until the judge approves the disclosure statement and tells us to send the plan and disclosure statement and ballots out. In that situation, after that, we can contact creditors and see about doing some sort of negotiation. But before we file the plan, before we propound the plan, we'd like to see if there's a way to get creditors on board, and there may be a creditor that we can identify early on that's going to be a problem child. That's when we do this sort of negotiation. So, well done. We can usually get a creditor on board. Sometimes it's simply not possible. And if that's the case, then we're going to see if we can't get the plan confirmed without that particular creditor's consent. One way to do that is if we can do a subchapter 5, Chapter 11. In subchapter 5, which was added a couple of years ago, we have a more streamlined process. And one of the important aspects of it is we can get a non-consensual plan confirmed. That means that the judge can confirm the plan even if we don't have consenting classes of creditors voting in favor of the plan. There are some pros and cons on that, but the subchapter 5 is only available for small businesses. So if the total debt exceeds a certain debt ceiling, and I'm not going to give the number now because right now that's in a state of flux. Congress hasn't decided whether or not to extend a certain increase in that dollar amount. So it's premature for me to opine on that right now. But if the debts exceed a certain dollar amount, then subchapter 5 is off the table. But if they are, if the total debt is less than that dollar amount, and at least 50% of those debts were incurred as part of the business activity, well, then we can do a subchapter 5, and that avoids the problem of getting a creditor on board. Ideally, though, we'd like to get the creditor on board anyway, because in a classic Chapter 11, there is no Chapter 11 trustee, and that gives us some real flexibility. And when the judge confirms the plan, the debtor, who is referred to as the debtor in possession, having authorities that are those of a, I suppose you could say, a trustee, a quasi-trustee, that gives some real flexibility. Although there are some real benefits to subchapter 5, one in particular, that we can have a non-consensual plan confirmed, The one drawback is there is a trustee in a subchapter 5, the subchapter 5 trustee. Now, that trustee's main duty, according to the bankruptcy code, is to get the plan confirmed. So that trustee can be a very helpful go-between to contact creditors and see what we can get worked out. If we have a consensual plan, that is, every class of creditor votes in favor of confirmation, then when the judge confirms the plan, the duties of that subchapter 5 trustee end. Now, we still have to pay that trustee for the time expended, but it ends upon confirmation. If we get a non-consensual plan confirmed, then that subchapter 5 trustee remains on board for the life of the plan and serves as the dispersing agent. What that means then is, in essence, you've got another creditor as part of the stew. And that creditor is going to have to be paid for his or her services as the plan progresses. So, as I said, there are pros and cons here. But the key thing is find out what the creditor absolutely must have. And if it doesn't get it, it simply can't live with whatever you're propounding, and give that creditor that if it's possible. Long-winded answer to a short question, but there is a lot going on in Chapter 11, and I think it's important to have in mind all of the moving parts.